help evacuate.
Hello, hello, hello. This is Attorney Mike Graven coming to you from Chicago as usual. It doesn't look like they've started yet, but I'm here. All right. Well, I mean, since we got time, let's give it an official intro. Okay, somebody tell me when that comes on. I can't deal with that background music. Maybe I need to do this for visual cue. I'll turn the volume on when it gets going. All right. So what do we think? Does he get violated from probation? Oh, hey.
To them, and he's like, no, I used this before in Boulder City, and it worked. And I'm like, no, stop.
Ignore all that stuff my attorney did that might actually help me. When I first met Kim, I have a whole playlist on this. The first time he came on, he took exception because I called him a sovereign citizen. And he just did the most sovereign citizen thing possible.
By the way, Mike, did you shout out our Nevada judges?
Okay, is this thing happening or what? How's the volume?
Yeah, I remember him bristling at being called a sovereign citizen.
Well, then don't act like one.
Yeah, you're making a good point. Maybe I might go full soft sit here.
That is its own charge. It's another thing is we're ostensibly at a probation revocation hearing. A lot of probation revocation, and I don't do this, but it seems to me that a lot of revocations, there's an exception. It's like, hey, if you get a traffic ticket, we're not talking about that. But if you pick up another charge, an actual charge, we'll revoke you for that. And passing the false document is a distinct separate charge as opposed to just traffic.
And he's the one who's presenting the evidence that he used this in Boulder City. This isn't the prosecutor. He's doing the prosecutor's job.
I don't know how you did it.
I mean, he's smarter than me and Joe combined, you know?
That all made sense. I would try to derail it the way Gersten did, although it's a bad objection. She understood it and ruled the right way. I get why everybody was. I understand why Dickerson's doing what he's doing. I understand why the defense attorney's doing what he's doing. I understand why the judge did it.
Do you understand why Blandino's doing what he's doing?
No, I'm lost. After all that. We continue to Monday. I did not watch this. Like I said, I had some ideas because people told me things in comments and messaged me. But I didn't.
Yeah, I saw about an hour's worth of it or so before I went to bed last night. Oh man,
I don't.
He continued. Got a cliffhanger here.
Because it's a sacrifice to come and do jury duty. So I thank them for coming in. And then I explain to the potential jurors, look, there are reasons why you might be excused. For instance,
I have to tell you, one of my heroes who has passed is a gentleman who I went to law school with, Judge Patrick Flanagan. And he had probably one of the best juror instructions that I've ever heard. And a lot of it had to do with how many people have fought and died for the right for all of us to sit in judgment of one another.
So a grand jury is not like a jury trial. It is basically the substitute or another route to take instead of a preliminary hearing. And there are many reasons that the district attorney might decide to do that.
What would you do, Judge De La Garza, if you had a juror that wasn't paying attention or even to the point of falling asleep? Good evening, everyone. This is Michael Gibbons. I'm the Chief Judge of the Nevada Court of Appeals.
Have you ever had a failure to appear?
Possibly.
You have been lucky enough to serve on a jury, and if you have not served on a jury before, I strongly encourage you to want to serve on the jury. It's one of the few areas that applies to everybody in the public. And these questions that I will be presenting to the panelists tonight are largely based upon questions from the public that have gone through the Our Nevada Judges website, where people are interested in finding out some of the intricacies of jury trials and why judges handle the proceedings in certain ways. So tonight we have Judge Maria Gall from the District Court in the 8th Judicial District in Las Vegas. We have Judge Melissa De La Garza from the Las Vegas Justice Court in Las Vegas, and Judge Shelley O'Neill from the Reno Municipal Court in Reno. Before we get into specific topics, I'd like the judges to introduce themselves in a little more detail. We'll start with Judge Maria Gall. Judge Gall, if you could explain to the viewers your basic duties and what qualifies you to do the work of a district court judge.
Thanks so much. The district court is what we call the court of general jurisdiction. And we hear civil claims of 15.
Have you ever had any history of substance abuse issues?
I've smoked a lot of weed.
Of course, the family court hears family law matters. So that's just a very general overview of what the district court here does. My docket is an all civil docket, which means I presently do not hear criminal cases. I only hear civil cases. And just so that the audience knows, civil cases would include, for instance, your car accidents, your personal injuries. You might have a real estate dispute, or you might have a small business or a contract dispute. So I see a lot of those cases that come before me. What qualifies for me to hold this position? Well, I have over 15 years of complex litigation experience. I practiced with a number of firms. I have also been.
Mm-hmm. Okay, I'm assuming that's a yes. Okay.
Judge. And so I went through this process where the Judicial Selection Commission, consisting of our Chief Justice of the Supreme Court, and then a number of people who are on that commission, a number of attorneys, but also a number of lay people. They review a very lengthy application that took me about 60 hours to complete. They do a background check. They call up people that you've appeared with, judges you've appeared in front of. They ask all kinds of questions about you, and then they nominate you to the governor for appointment.
What is the requirement in terms of being retained by the voters?
You have to, under the Constitution, appointed judges have to run in the next general election. For me, the next general election is actually this November.
Okay. And you indicated that you are assigned to the civil portion of the 8th district right now. How was that determined? And what if there are criminal cases that need to be heard by jury trial? Are you also able to hear those cases?
So I am able to sit on both types of cases. We are assigned our dockets through the pleasure of the chief judge, who is Jerry Weiss.
Garza. I am a judge in the Las Vegas Justice Court. I preside over Department 15. I was elected for this position, and I've now been on the bench for 4 years. So I ran in 2018 and started in 2019. I currently preside over the battery domestic violence.
If you haven't hit like and subscribe, I just want you to know that you're hurting Jack's feelings.
After I started, our Supreme Court came down with the decision that people charged with battery domestic violence were entitled to a jury trial. So we had, and I have had, along with the other judge that had the other track at the time, Alana Graham, and now Judge Dotson, we were responsible.
The wheels of justice are going to roll you right into the Wayne County Jail.
Do jury trials. Justice Court is a court of limited jurisdiction, so we do civil up to the 15,000. After that, Judge Dahl and the 8th Judicial take over, but below that, we handle small claims, and we also handle basically the entry of cases on the criminal realm. So when somebody's arrested, we do the preliminary hearings for gross misdemeanors and felonies. And then if they are charged with the misdemeanor, we'll usually do a bench trial. But in the case of battery domestic violence, they also have the right to a jury trial. Before I started in Las Vegas Justice Court, I had been a hearing master for the 8th Judicial for 8 years. Before that, I had my own practice for about 3 years. Before that, I was in the public defender's office. I did homicide cases. And before that, I was in the district attorney's office for 8 years, where I did probably between those two about 40 to 45 jury trials. So I have done jury trials as an attorney. Since now having jury trials in the Justice Court, we have done 2 in the Las Vegas Justice Court. We were ready for so many more. We really expected a lot of jury trials. We set up our system to be able to handle 5 or 6 a week. Even though we set them each week, like I said, we have had about 2 at this point.
So did you also play a role in putting together the bench book, which is the instructions for judges of how to conduct a jury trial?
We did. Actually, Judge Graham and I sat down and we gathered some of the jury instructions from the 8th Judicial and from, of course, case law. We also
See, I'm going to use Miss Fowler's word. She now is in a throuple. And not only does she choose to be in a throuple, and she's shacked up in the bed with the throuple. Now, if anybody thinks this is okay, I am in the wrong world.
municipal courts were not really set up initially to do jury trials. So we've had to do some modifications, but yes, we sat down. It took us a few months, but we did come up with a bench book for battery domestic violence jury trials.
So this essentially is to help judges that haven't done a jury trial before to properly conduct the trial?
It is, because in Las Vegas Justice Court, in fact, justice courts in Nevada, some of our judges have not had jury trial experience. Additionally, some of our judges in rural areas in Nevada might not even have legal training. They might not be attorneys. Duty of doing a jury trial. So
That's
we
seriously
try
weird.
to give them basically a dialogue of sorts, just to give them a script, so to speak. Give them a script, give them the laws, give them some of the things to look for if they did have to conduct that jury trial.
How about get a real judge?
Just a heads up, we'll come back to a question of what happens during a pandemic for a jury trial. So we'll save that for a little bit. We'll move on to Judge O'Neill.
Thank you, Judge Gibbons. I appreciate the opportunity to be here today. My name is Shelley O'Neill, and I am the Chief Judge of the Reno Municipal Court. I have served there for 16 years after being elected to the position in 2016. Happily, I'm on the ballot again.
Okay, I'm assuming that's a yes. Okay.
You're the only court in the state of Nevada where each of the judges in our court has a specialty court. I'm proud to say that one of my proudest moments is that I created a veterans treatment court here at the Reno Municipal Court, the first misdemeanor veterans treatment court in Northern Nevada, and am able and have been able to take a number of cases in our veterans court from across Northern Nevada, providing those rural jurisdictions with the opportunity to have their veterans placed in our program. And pretty importantly is the fact that the Fallon Naval Air Station is using our services for now active duty military people, because if they were convicted of any kind of a misdemeanor offense, it would be a career ruiner. My qualifications for this position are that I've been a lawyer for going on 45 years. I was the chief public defender for 13 years and tried about probably the same as Judge Lagarza, about 80 cases, including death penalty cases, when I was the chief of the public defender's office. I went on to run the antitrust division of the Attorney General's office.
Unfortunately, I've got a deposition starting at the same time.
I've been a prosecutor for the city of Reno for
I think John is covering it though.
And was in private practice with my husband for 16 years before being elected. I'm really happy. My court has been nominated and has received the accolades of being the basically, I say the best court in the state of Nevada. We've won that award on more than one occasion. And it's because I believe that each of the judges in our court work really hard to provide justice with a little element of kindness and respect that you don't often get in a lot of courts. That I'm really proud of the people that I work with here, from the clerks in the clerk's office all the way up to my colleagues.
Mm-hmm. Okay, I'm assuming that's a yes. Okay.
Is up for election, and we've convinced the Washoe County Library to hold that homeless court, community court there, because we found that many homeless people are afraid of the courthouse. Many of them sleep around the courthouse for security reasons in the night, but they're afraid to come in the building during the day for any kind of service. So Judge Hazlett Stevens and one of my colleagues who's now moved to the district court, Judge Tammy Riggs, got together and they have acquired about 25 to 30 local providers from Social Security, food stamps, book a person in, including police officers' time. And so we've convinced the police officers, and I think that they were easily convinced, to ticket those offenders to the community court, where they appear every Wednesday morning at 8. They're provided a coffee and donuts. They're provided those services. The judge sits and we have, through the city of Reno, if a person does not want the services, and we have a number of people who refuse those services, then we give them a vest and a lunch. The Washoe County Jail provides a box of free lunches, and we have a van that's been provided by the city of Reno, and we have my former head marshal, who has arms about this big. He is the driver of the van and takes people out to do community service immediately. So there's no gap in time for people to get their community service accomplished if that's what they're ordered to do. So it really is an efficient program. We have an average of about 50 people every Wednesday that we've kept out of the Washoe County Jail and out of the criminal justice system with those services. So we have some wonderful programs. We have a mental health court, we have a young adult recovery court, and a fresh start program. All of our judges have worked really hard to write grants, and each of us, I'm proud to say, have gotten about close to $1 million for each of our programs through the Department of Justice. So we are one of the few programs that can pay for testing. We have a psychologist in my Veterans Treatment Court. We have a team of 10, and we're being recognized by the governor's office in a couple of weeks as the as a leader in providing services to veterans. And I'm taking the whole team to Carson City.
I'm amazed to hear how many programs there are in municipal court. So are you ready to do a jury trial too in municipal court?
I'm ready. We actually, when the first ruling came from the Supreme Court, there was a limit of 6 jurors. And so we spent about $80,000 building a jury box for 6. And then there was a modification of that decision. And now it's a jury of 12. And what criminal defense lawyer would turn down 12 people when they had the opportunity? So I totally understand that, but we are in the process of rebuilding our jury box. Because of COVID and a number of other reasons, we have not had a jury trial here. I've had about 140 based upon my lifetime experiences in all areas, both federal, civil, and criminal, including death penalty cases. So I'm prepared to do a jury trial, and my other colleagues will come along. In fact, I want to thank Judge De La Garza and Judge Graham for the bench book, because it was really a welcome addition to the fraught that we had about the small jury box and judges not being able to understand what's going on. So we really appreciate their hard work in providing that resource to us.
Mhm. Okay, I'm assuming that's a yes. Okay.
What types of cases is a person entitled to demand a jury? So Judge De La Garza touched on this regarding the battery of domestic violence. Is there any other type of case in justice court that would possibly have a jury trial?
In civil cases, they can demand a jury trial, but for the criminal cases, it's the battery domestic violence. And that basically came from.
What's up, brother? How you doing?
Hey, how are you?
Yeah,
I
was texting with Ben. You said you were just in court and they hadn't called him up yet?
Yeah, in fact, I had hearings. That's on the same floor. Actually, the courtroom I was at. The judge, I don't know, there's another judge covering his calendar today. So it was on the 14th floor, just down the hall. And so I did run into Joe Gersten, spoke to him briefly, and put my arm around him. Said, it gets better. It gets better, my brother.
A little moment, yeah.
Yeah. We are an exclusive fraternity there.
Well, that's interesting. I hope they get going on this thing.
Yeah.
You know, Brooks is up at 1:00 my time, whatever, like in a 40 minutes or a half hour.
Oh, but today was just it was a scheduling hearing, right?
Yeah, it was just a scheduling hearing on that. But I still wanted to do it. I have a deposition at the same time. And then I texted you this morning. I'm like, hey, this thing's going, at this time. And you're like, yeah, well, I've got 3 hearings up.
I know. Actually, I have a 4th. I didn't realize I got appointed on a new case today that I got to go back up.
Anything we need to know about?
He shows up. No. Yes, actually, I take it back. I came out of, since I told you that hearing was on the 14th floor, I come out of the courtroom because the judge is covering 2 calendars today, and I walk out, and there's this guy sitting on one of the benches out there, and he's smiling at me. He's like, "Hey, Ben Bateman."
Sorry, she's asking for any public defender or defense attorney to stand in.
Okay, give me 1 sec. So I don't know what that's about. So anyway, I'm there on the 14th floor, and this guy's like, says my name, and I'm like, I don't recognize this guy. Is this my client? Anyway, it was a guy from Detroit who's a Law Talk with Mike subscriber. He's in town in Vegas for a convention. We have, every once in a while we have a convention here in Las Vegas. He's here in town for a convention and was like, oh my gosh, he came down here, was waiting outside of the courtroom, and then recognized me. And then Alex Falcone from Our Nevada Judges, which you should all subscribe to, was there. And then he's like, oh yeah, let me get a picture. So he got a picture with Alex and Brittany. I took the picture with Alex and Brittany. He didn't want my picture. But anyway.
He's an Alex fan. All right, I'm being told it's on.
Oh, hang on one sec.
Hold on a second. If I may approach, Your Honor, I'd like to get Defendant's Exhibit A.
Sure.
That was the probation conditions.
Yeah.
Thank you.
Make sure we get that done.
Yes, yes. And again, court's indulgence, I'm just trying to find the violation report. I'm trying to get the violation report.
I'm gonna copy it right now for him.
I'm gonna find it for you.
Mr. Garrison, if you want to approach.
Thank you, Your Honor. Thank you.
Okay, go ahead, Mr. Blandino.
Well, the reason why I wanted this probation report is that they've got non-technical stuff on here. This was done in September 2022. And
Sorry.
I did go to.
Gotta take care of something there.
Evaluation is required, paid the fees. On the very day I was arrested at 3:15, they did it, and Officer Duque did admit over the phone when I called her that the report was done, the mental evaluation report was done, and that I did not need any further counseling. So this charging document, and I presume it's a charging document, is not current. I want to note that it still
Who
says
did
I
the
have
evaluation? Who did the evaluation?
ABC therapy over there on Eastern. They charged $123, which I had no idea when the sentencing was done, I was at to pay for that. Nor the ankle bracelet that they charged $12 a day for a month. And that's not on this report. But you'll note that it's 297 days per the PSI is still on there. It was stipulated in court that I was 134 days credit time served. So I'm tying this into the testimony for what Eric Chandler said. It was indeed truthful. He said there was a long conversation. This document, he went over, we went in person on the parole and probation office over there on Bonanza and whatever that cross street is. And there was indeed a long conversation. And they said, look, there's no way I can sign this because I can't understand it. If I say that I understand something and sign something, that would be a lie, and it's filed in the court. I could be charged with perjury for that. Each of these conditions, these special conditions, I understand something can be placed on intensive supervision for a time, and I did do 1 month with the Scram people. It's a private subcontract to that organization. I still owe them some money for the ankle bracelet. Have no direct or indirect contact with the victims in this matter. So according to that, I understand that that's Federico and Mr. Marlowitz, according to the charging document and what was presented in court. Marlowitz was claiming to be a victim. Not to file any documents unless consistent with the vexatious litigant order. You have that order. There was an order filed by Judge Bell that modified the vexatious litigant order and allowed me to do the probate on my mom's estate. She's dead. And she modified the vexatious litigant order. So I couldn't sign for that because it should say consistent with the vexatious litigant order and the modification order issued by Judge Bell. I got a certified copy. I gave it to counsel and he can't find it.
But what is he talking about? I got lost reading comments.
That is not correct. It should have been.
About his mom's
unless
probate?
consistent with the vexatious litigant order and the modification order listed by then Chief Judge Bell. Not to file any fugitive documents. This now, on its face, Eric
no idea,
Chandler
man.
did not know, I'm Officer Chandler.
Well, that makes
He
two
did
of
not
us.
know what a
That's
fugitive
good.
document was.
I need to get-
frankly,
I need to get my
do not
ass cut
fully
on
know
for him.
what it is. My notice of appeal.
Don't you have
is
a
the only
deposition
reason
in
why
like
I've been
20
so
minutes?
pending.
I do.
That was filed.
I thought this would be
because
done.
counsel wasn't even aware that
You might have to carry this thing, Ben.
an appeal can be taken
I'll
from
do my
the
tech
verdict
with my
under
phone.
Winter versus State, and under the statute, you can either appeal the verdict or the judgment of conviction. I'd like the record to show that Mr. Gersten did not file any any notice of appeal of this judgment conviction. Therefore, the time has passed, it would be late. So was my notice of appeal a fugitive document? Was my motion for a new trial motion a fugitive document? In the Nevada Supreme Court, even though they force counsel on me, they allow in their rules, the Nevada Rules of Appellate Procedure, for me to file a motion to remove counsel. That is specifically allowed. Now, do I have that right to file a motion? I couldn't risk the chance that I would be violated on probation. So that is not an understandable order. I could not understand.
I understand
The
it.
definition of what this court meant.
How can
by
the
fugitive document
brilliant
is
legal mind of Kim
overdefined.
Blandino not understand a
I
legal
undergo the
document?
mental health evaluation and completing.
I heard on the call from jail. He knows more than me
Have no
and
contact with
Joe
Mr. F at all.
combined.
Presuming
Yeah.
it's Federico. That's true. I haven't.
So
Defendant may contact Mr. F's attorney only for legal matters. That's understandable. Clause 6. Submit to a full financial disclosure to parole probation as deemed
Is
appropriate.
that Joe next to him?
As of yet, they haven't asked for it,
Pardon?
they haven't deemed it appropriate. Have no contact
Oh,
with the
okay.
courts. Now, this is brilliant. And this is absolutely.
Whatever.
brilliant.
They're back
I have
right next to
already
each other. I thought it
contact
said
with the,
DLC on the back of Joe. I'm like, that doesn't make any
US
sense.
District Court. I had
No,
two
there's
nothing
lawsuits
next to
each
before,
other.
one against Mr. Federico and one against LBM PD and other Doe defendants. I have contact with the US Supreme Court. This
no, Greg,
is
see, I'm not.
crazy to
It makes
think
me
that I
laugh.
can understand what
I'm not gonna let it go.
with the court. I can't have contact with the
I'm
Las
petty
Vegas
like
court.
that.
I have a thing that I need to get addressed there, where they dismiss the ticket without prejudice, and I want to change that to with prejudice. It's about 3 years old now, on a no prosecution. I have the right to, this order is in fact illegal, these special conditions. It's an illegal sentence. In fact, the judgment of conviction is illegal under all the case law and 176.555.
Why hasn't he claimed diplomatic immunity?
By motion.
Oh.
And what makes it illegal
He's got
is
the passport and the
134 days that I was, that the
He's a
district attorney
diplomat.
admitted that I had credit on that sentencing day is not in the judgment of conviction. I'm entitled to that by law.
Generally telling
by case
judges their
law,
orders are
by
illegal
statute,
is a
in
poor
every
play.
way. And to see this reflected in the
Yeah,
parole
usually they
probation giving me much more time than 134 days. And that's what I was given in the PSI report. I begged counsel to say, you need to put in a motion to correct the PSI report. You saw me stand here and say that that 297 was not correct at sentencing day. It needed to be corrected because I don't want to be charged with trying to receive good time credits I'm not entitled to and possibly criminally prosecuted for trying to accept something fraudulently. I believe in the truth. I'm testifying to
Okay.
the truth now.
We'll impose
So, Your
sentence. then.
sentence, Judge, was illegal on that day. It's illegal as to these conditions. I am not supposed to be able to require.
Probation was
Yes,
illegal?
what you meant by these conditions. Now, I have to note that the conditions you gave me to stay away from the RJC and later on, because the city court moved from this building to their own building, later on, it was asked by Mr. Dickerson and granted by this court pre-sentencing that I stay away from the city of Las Vegas municipal courts. That's understandable, but I go to the Nevada Supreme Court and the federal courts all the time. Sometimes I go to the Nevada Supreme Court just to say hi to the Davis and Marshals. 'Cause they're nice guys there. As a matter of fact, I went for oral
Just to say
argument
hi.
to the Nevada
Just to say
Supreme
hi.
Court
Oh,
in the
yeah.
case of Marlon
Supreme
Brown
Court.
versus the warden.
That's Supreme Court's
Which
like time,
were
apparently.
prosecuting, the
There's the
judge
cheers where
in
they
the
say,
underlying
Norm.
criminal case.
It's like that with
In that case, Marlon Brown, which is now on appeal
Yes,
on the
I am
denial
grateful.
of the habeas corpus writ. Do not enter the courts unless the defendant is present for official business. Now, this is completely rich. I was prosecuted for claiming to be an official. I can't do any official business because I'm not an official. I'm an unofficial investigator for the commission or with the commission on judicial discipline. Unofficial. So
It
what
never
does
ends.
that mean by official
The same,
business?
the same
Do
argument.
not enter the courts unless the defendant is present for official business. I'm not.
So
an
he can
official.
go for unofficial
I call the
business.
clerks when I see a mistake or a problem. So this actual hearing, the probation revocation hearing, is completely out of order because the sentence was illegal. I'm entitled to a new sentencing hearing and a new sentence. There's another reason why this is wrong. I was not given full disclosure. At no time at sentencing was I told that there would be a charge for the ankle bracelet on parole probation and that I would have to pay for the mental health counseling. As you know, there's a recent case law, Judge, that I am entitled, if I choose to reject probation and to take the sentence. I am not required to take probation. I begged Mr. Gersten and Bateman
No, you're not.
before we came to the sentencing hearing.
So we'll impose
put in a
sentence.
motion for
Hey,
bail
said my
pending
name.
appeal if I get sentenced, if not for a stay of probation.
Your Honor,
There
may I
was
ask
a
for a step?
motion for stay of probation filed,
Huh?
and it was denied.
Yeah, but it was filed too late. It was denied on the basis you didn't have the power to grant it because it was already on appeal.
May I ask for a sidebar for just 2 seconds?
Sure.
Apologize.
I thought this. We did this Saturday. I was at a hotel room. I'm like, they took the witnesses. It's a revocation hearing. They've already taken the testimony. This can take no longer than 10 minutes.
Come on. This is your first Blandino hearing?
My God, I'm gonna have to go do my deposition.
Is it at your office there at least? Like, or is it?
No, I just have a deposition in the case.
But is the depot being held at your office or wherever you're at now?
It's being held. It's a Zoom up.
Oh, okay.
I don't think I'm going to keep the ascot on for the deposition.
Come on.
I mean, it's a dep. I could, but
Specifically,
maybe I should.
It's very sophisticated.
because you have already testified. So anything further?
I'm trying to rebut in total and to present what I told Eric Chandler, and this is very important. This, with the conversation we had, because it was an extensive one. Like I said, he sat in front of me with this form and told me, if he would have said, Mr. Blandino, you're gonna have to sign or we're gonna violate your probation or make a report or whatever. He was comfortable, he said, chose not to sign, he used that language.
That's already been testified
Okay.
to. So
Anyway,
again,
I want
I
to
asked you
confirm that, but I
to
want-
get to the point,
I had
a
to
new
tell him,
point,
I had to tell
not
him,
repetitive testimony.
I had to tell him that, and I told him that that sentence was illegal. These conditions were illegal, they
You've
weren't
said that
understandable.
now
We've
about
heard.
3 times.
Yes, we've heard.
Quick, to the point, no
I
faking.
said that
Let's
this
go, come
judge
on.
herself was on probation because the Commission on Judicial Discipline called her, that they lied to her, and that you admitted to violating.
Oh yeah,
Rita Downson's
Joe's not going to
rights.
say any of the
That I
things
was
Kim just said.
investigating you
No
for some
way.
time, that this conviction would not
Anything
stand.
You don't think so? You don't think he's gonna say, Judge, that was an illegal order? How dare you?
And you refuse to disqualify yourself.
I'm
And you now,
going to-
Judge,
done.
you are now committing
I'm
a crime.
assuming that he's done.
You are committing a crime.
Oh.
You're done.
197,
I mean, this is
2.3.
like,
Committing a
this
crime.
is absurd. Okay, so he is done. Does the state or the defense have any further witnesses? I mean, you're not gonna turn this into a circus.
Nothing.
Too late, Judge.
Might be too late for that.
All right, I'll hear from the state.
Thank you. Your Honor, we are asking that Mr. Blandino's probation be revoked. Currently, as he sits here today, we're showing that he has 342 days credit for time served. That is not counting today, because of course, if his probation gets revoked today will count as the day that his sentence starts. That means as well that he is looking at a 12 to 121 sentence in the Nevada Department of Corrections. In 23 days, he will be eligible to go before the parole board. 23 days. It's time to put this to an end. It's clear what's happened here. It's clear that Mr. Blandino was just up to the same thing he's always been up to. Here in this particular instance, he's indicated that essentially he didn't agree with the terms of probation as you laid them out at the time of sentencing on July 7th, when he was present at the time and heard your rendition of sentence and heard all those conditions of probation. And so he didn't sign his probation agreement. In further, we go into what occurred thereafter, where the defendant comes before this court now, having been arrested on a new felony offense. He admits to Your Honor that those 2 passports that he has, those are his passports. He admits that those are also his driver's license, his international driver's license, as he called it. He admits that he used those dozens of times. He has authenticated the documents that were contained within there, which show that he faxed that same, one of those same passport, fake driver's license to the Boulder City Municipal Court as it was used by him at that time in the 90s as a driver's license. He admits that he was doing that same thing during the traffic stop in this case on September 16, 2022, attempting to use those passports as his driver's license. He further admits that he even showed the officer, Officer Martinez, that passport. He then tells the detectives who arrived, yeah, those are my international driver's license. That's my driver's license. Under NRS 205.465, subsection 1 is unlawful for a person to possess any document or personal identifying information for the purpose of establishing a false status or a false license for himself or any other person. Here in this particular instance, he's done just that. Further, I think that it's clear on subsection 4 that he's committed the category E felony, but I would argue that he's probably also likely committed the category C felony under subsection 2A and B, with transferring and possessing that document with the intent to commit forgery. So based upon all that, based upon his non-technical violation here, based upon his overall rebuke of probation, as he's testified to right here in court, his probation should be revoked. We are asking that he gets the full credit for time served that he's owed, 342 days, with 23 days until he's parole eligible on his 12 to 121 sentence in prison. If Your Honor has any further questions, I'd be happy to answer them. But my assessment of all this over the past 2 hearings is that the defendant, he's essentially just admitted to everything, that yes, he was violating the law, and yes, he rebuked the probation grant that you gave him. It really leaves the court with no other option but to revoke his probation.
Thank you, Your Honor. I'm going to take the motion to impose sentence first and then move on to that. Just simply with the motion to impose, Your Honor, it was simply based on his non-signing of the document. I believe Mr. Blandino has at least made a case that he didn't understand what he was signing. Officer Chandler didn't have a problem with it. He said he's never happened before. He didn't push it up the line. There was no issue. Mr. Blandino, to the best of his ability, has been following his probation. He's behind a little bit on a couple of fees. He doesn't work, but completely understandable. I don't think that's a reason, again, to impose the sentence. I will say this, we were in the middle of actually preparing a motion to amend the judgment of conviction for Your Honor to consider when all of this happened. We are obviously holding off on that to see what happens here, but again, I believe that that is really a non-issue in this case. With regard to the second issue, which was the traffic stop, Your Honor, prior to Mr. Blandino testifying, I think Your Honor would agree, the state failed to prove that Mr. Blandino had presented his document or really done anything to pull him into this ambit of committing a felony by providing a false document. None of the officers could say that it was presented, that they saw it, that anything of that nature, again, before he testified. So the state's evidence, I believe, was lacking in that regard. Obviously, Mr. Blandino testified against advice, but again, that's his testimony, and I would submit that his testimony is just in question. Because again, what did he say that he did? At best, he has a novelty passport, and it's an Israelite passport. That's not a legitimate document, as anyone should know. Again, there have
I
been,
agree with that statement. I'm just not sure your client does.
again, Your Honor.
Great argument.
Yeah,
I can't help that.
Cutting it,
You know,
like
I
you pointed out, man.
but it's true. So for the officers to
dear.
sit there and, again, after the card's been
What's your instinct
pounded
say, Mike?
to find this document and then suddenly believe that this is a true document. Detective Shai was saying, you know, biblical verses. He called the State Department. Like, they don't even know what this thing is. It's housed in a Mercedes-Benz cover. I mean, it's just not real. And I don't believe. And again, I would submit he never presented it for any benefit or anything of that matter. It's not real to begin with. So in that regard, I don't think he committed a felony, which would be required under the statute. Potentially, he potentially committed 2 misdemeanors: not having a driver's license, not having the car properly registered. Although, he claims to have a lifetime registration in Montana. So I'm not even sure that particular charge is viable. Potentially, he didn't have an actual driver's license under, if I may, under NRS 176A, I think it's 630. That's a technical violation. Graduated sanctions, he should be given 30 days. I believe he's been in already about 30 days. Even if Your Honor the technical violation, that was 1768.51. That's the technical. Your Honor, if you believe that Mr. Blandino actually did something wrong here, because remember, as kooky as he is, he was simply trying to alert someone on the road that they had a light out. He did not do it in a proper or safe manner, but really that's what he was trying to do. That's all he was trying to do. Under 176A.630, if you do find any of this, you have a series of 4 things that you yourself may impose. Starting with, under 1A, you can continue or revoke the probation or suspension of sentence. You can order him to a term of residential confinement, which is what, if you do choose to consider this a non-technical, we would ask that you do that. I mean, obviously, you could send him to regimental discipline, but I don't think he's built for that, if you will. So again,
Regimental discipline, that's boot camp,
considering
basically.
the totality of the circumstances of what we're talking about, he's kooky, but I'm not sure that he actually committed the felony, number one. I'm not sure there was enough evidence presented by the state to show that he committed the felony. Potentially a technical violation.
How fitting that this is heard on Halloween.
He really just needs to get back to his residence so he can take care of Evie.
Yes,
who,
I called him quixotic.
If you will. That's all he's simply trying to do. And with that, I'll submit.
So, counsel's arguments rest on the document not being a good enough state. That is not part of the statute here. That's not part of NRS 205.465. Here, defendant committed felony. Undoubtedly, committed felony while on probation 2 months after Your Honor gave him the opportunity. The document here was used by the defendant for the purpose of false license.
I think he's gone, man.
That's the felony. With that, I think that we go further into the same argument that he's used time and time again, that he needs to get home so that he can take care of Evie. Evie, Miss Pendergraft, is currently in an assisted living facility. She's currently in a better place and with adequate care than she otherwise was and will be with him now. I'm not going to disclose which assisted living facility on the record, but that is what has occurred in the meantime. Further down that same line of argument, since it's been brought up, when the state previously came in and told Your Honor that we were going to be sending adult services and abuse and neglect potentially over to see Ms. Pendergraft when the defendant was in custody, the defendant called Ms. Pendergraft and told her, and her son, and told her that they needed to post the property with no trespassing, no government official signs, because he doesn't trust the folks from adult services or the government at all to come in. Since that time, she's been in a much better situation. She's currently being looked after.
She has a son, did you say?
No, Mr. Blandino's son.
Oh, okay.
And so with that, Your Honor, it's clear, it's beyond what is required for the state's burden in a probation revocation hearing that the defendant has committed a felony here in this particular.
Come on, Judge, roll. I got a debt.
2 months after this grant of probation. So we do ask that you impose the full sentence right now.
Yeah, Dickerson, wrap it up, dude.
Probation sentence. It's the same probation sentence that he himself refused.
All right, anything else?
If I may, Your Honor, I apologize. Just
You're fine.
as far as the use concerned, Your Honor, if you recall, at one of the prior hearings, Mr. Dickerson said, hey, we sent over, she's fine, adult services checked out. Either that day or the next, she had to go into an assisted living or hospital. So what Mr. Dickerson's comments about her well-being and whatnot really are suspect, because in court he said,
I think I can handle both.
and then she ended up the next day.
Are you taking or defending the depot?
hospital.
She's like 96 or 97.
87.
I'm producing my client.
Understood, Your Honor. And again, I don't want
They hit
this
my
to
client. It's
become
easy.
the focus of this hearing. It's not.
But I
It's
gotta
a
go.
side piece.
Damn.
But just so
All right.
Your Honor.
I'll keep this going.
Mr. Blandino is haranguing me, Your Honor, just to let you know that he believes he is entitled to have a jury determine a felony, and he would object and request that. Again, that's his request. Other than that, I believe I can stand on the other statements I've made.
That's the remark regarding.
Come on.
Going to the hospital.
Quit having, yeah.
Calls that were
Wanting
made
the
by
last
defendant
word, guys.
after that hearing. The defendant spoke to Ms. Pendergraft while she was at home. He spoke to her, and he goes through running through her health concerns with her. Says, "How are you feeling?"
Well, Your Honor,
How are you feeling?
I have to object. He's testifying as to what Ms. Pendergraft said on a phone call. We're beyond
I'm
that.
not testifying. I'm arguing. I'm arguing in response to what he's arguing.
Go
But there was no evidence.
He asked her, how does she feel? She says, I feel good. My health is good. My knee kind of hurts.
Oh, damn it.
Mr. Blandino proceeded
Okay.
to convince her.
All right.
I'm behind the scenes. I'm monitoring, but I gotta check in and get this stuff started.
He wants no trust.
I'm just gonna pause my
He doesn't
camera.
trust the government. He doesn't trust adult services to come in. That she needs to go to the hospital. And then she does. She goes to the hospital, and it's a good thing she did, because now she's.
Sabs, we need one. I need a T-shirt that says that.
But all of it seemed to be under the guise of Mr. Blandino trying to hide her from adult services.
Gerson's done. He's not responding.
At this time, the court's going to reinstate you on probation with the added condition. You do 30 days in the Clark County Detention Center.
What?
On being released, you'll be subject to intensive supervision pursuant to NRS 1768.440. Also,
I am
be subject
shocked.
to the additional condition that you are not to drive a motor vehicle in the state of Nevada without a valid driver's license issued by the state of Nevada and the Department of Motor Vehicles. How much credit does he have towards that 30 days?
Yes. At this time,
He's
should
over
have-
30.
More than 30.
Well, from when he was placed in custody.
Okay, I'm waiting for the host on that. What did she do?
She reinstated him with 30 days in jail, added condition, have a valid driver's license issued by the Nevada DMV.
45 days credit for time served. When you get released, you need to report to pro probation within 24 hours so you can be placed on house arrest.
The judge, he ordered a release immediately. They take days to have the seat.
Thank you, Your Honor.
Thank you.
Thanks, Judge.
She just walked out.
Wow. No way. I can't believe that. Man, I should go run up on the elevator, try and catch him. Should we get a post-exit? interview here. Oh my goodness.
Wow. All right.
I was shocked.
Well, I'm waiting. I'm waiting for the host to let me in here, so I will. But thank you for coming by. I don't even get what
I was
happened.
shocked. She reinstated him. With the added condition.
But he didn't sign it. He's not even on probation.
I don't know. I
don't even see how she does that. I told you she wanted to. That's what she wanted to do.
Yeah, I started singing on.
Oh, I just lost you, buddy. All right. Well, thank you all for coming out. I think John is streaming. I got to go to my dep. John is streaming the Brooks thing. So you go over there. And obviously, if there's anything more on, I just turned it off, but I don't think there is. Our Nevada judges, everybody go over there and give them a like on that video. Thanks, Ben. Thanks, everybody.